Statute of limitations, we go over it in the materials. I'm going to say now, for prosecution, you're talking a child right now who would be abused. We can prosecute up to the time that child is 50. I don't know how you do that, frankly. I think it's illusory, but you can't extend for those. For criminal, it's definitely ex post facto. Once you, as a child abuser, have waited out the statute of limitations and it's run, you're done. We can't extend the statute and create windows. Can't be done under the prohibition against ex post facto criminalization of conduct. It's 50 for criminal. It's 50, and my understanding of the law is that it's well settled. It's ex post facto with regard to criminal prosecutions. Once the statute's run, it's run. I'm not as sure about civil. Our charge, however, is to deal with the protection of children. The issue of whether somebody who's now 35 or 40 should or shouldn't be able to sue somebody is simply not our. And frankly, I can't tell you how crazy it makes me that that's the idea that pops up with all of the stuff that needs to be done to protect kids, to create the ability for a certain group of people who, maybe had horrible things done to them, maybe they can't. How we're even going to figure that out 30 years later, except guilt by association, I have no idea, but it's not our ballgame. So others may opine on it, and the legislature will deal with it or they won't. It wasn't something that we felt was in our wheelhouse. I believe there's, yes, ma'am, thank you.
My question is, I was curious what your guests think about how the laws regulating the statute of limitations for child sex abuse will change in Pennsylvania going forward.
And Joanne, I have to say we have a third guest who will be joining us to talk in more detail about that. But let me give, I guess, Dave Heckler, let me give you a chance to weigh in on that.
We may both want to, but at any rate, right now, you can bring a criminal action. Any child who were victimized today, effectively up until they are 50 years of age, which is a heck of a long time. I wonder how we would manage to prosecute such a case. But for criminal matters, the statute doesn't seem today to be much of a factor. However, if the shorter statutes of limitations which existed previously, once they run, you can't extend them for criminal matters. It's an ex post facto law. We can thank Thomas Jefferson and the Bill of Rights. Civilly, presently, you have until you are 30 years of age, effectively, to bring an action, essentially 12 years after you turn 18. Again, the statutes used to be shorter, and I'm sure there are many people who cannot sue who would wish to. Our charge with regard to the task force was to look at the well-being of children today. We had, for all the same reasons that we had a wonderful task force in terms of prosecutors, lawyers trained in the Child Protective Services, juvenile court judge, and primarily doctors, we would probably not have been the right panel to take up the questions that would occur to me as a lawyer or a former judge about, well, civilly, do we want to extend this, to open a window? Some states have opened a window. I think your next person you're going to have on advocates this. A number of issues spring to my mind, including if there's a problem, what trial lawyers do for it is. I have my doubts, but
hold on to that thought too. Let me give you a chance to weigh in on that, Cindy. I know you're not a lawyer, but you must have dealt with or thought about this statute of limitation.
I recently moderated a panel up at Penn State. They had a 2-day sexual abuse conference, and I moderated a panel open to the public the night before the main conference, and we had a state representative. I don't think she would mind me saying her name. She's out in public, Louise Bishop, who was just wonderful, and 2 other adult victims. And I think she, she really waited until she was well into adulthood to kind of disclose and recognize publicly her past abuse. And I know from her and that these issues of being able to have some recourse in the courts is very, very important. We focused on a lot of issues. We didn't hear any testimony about kind of the statute of limitations. It was something that we didn't really discuss at length, but in my mind, I think there are individuals to whom that is very important. And, you know, our task force, these are recommendations. We're sure that there'll be some other people with other recommendations, and, you know, there's still the ability to do that.
Well, I'm sure we will have recommendations after this very short break.
Hi, I'm Amy Denisix from the Patriot News. It seems that a lot of the components of these bills deal with children, current children, obviously, and not with people who were abused as children maybe years and decades ago. And as you know, a lot of the advocates are calling for a window lifting the statute of limitations so that these people can bring charges against their perpetrators. Do any of these bills address this?
They do not. I'm told that there will be legislation maybe introduced today which deals with that subject. We specifically referenced in the report the fact that we did not deal with that. First of all, the statute of limitations, you have to remember there are two sides to the systems that deal with the abuse of children. There's the criminal side, where you actually prosecute, bring charges and prosecute people who abuse or are alleged to have abused children. The statute there is out to, I think, I should have prepped for this. I'm thinking at least 50. If you're a child, were a child and abused, I think you're beyond 50 before the statute runs. And from a prosecutor's standpoint, I've got to tell you, they're going to be extremely tough cases if somebody comes in at 45 and says, hey, my mom abused me, a priest abused me, whoever it is. There's statutes of limitations exist for a reason, that reason being that proof just over the years becomes hard to come by. The civil statute of limitations, I want to say 30 years of age. Now, we did not weigh in on that because we did not consider it a part of the charge that was given the task force because we're about dealing with children who are now subject to abuse. At best, we're talking about people who were abused 15 or 20 years ago, shorter period of time than that. The statute would allow even a civil case. I would frankly doubt the claim that all of the advocates or many of the advocates are talking about this. A narrow group of people who think trial lawyers are the answer to society's ills are talking about this. We took tons of testimony. I've forgotten how many days, 10, 12 days at least, of all-day testimony. We didn't have anybody asked to testify who wanted to testify on this subject. So that I don't believe it's so much the advocates, it's a noisy group of people who get a lot of press. I leave this to the legislature. And I suspect it has a lot to do with where you stand on tort reform in general, maybe. But we did not see this as something that dealt with the abuse of children now or even abusers, with the exception of a few, who would still be in a position to be abusing children. I mean, that's a big argument. Oh, if you let us sue the church, for instance, we'll get all these abuser priests. If you look at the time frame that's available for civil actions, you're talking about some pretty old folks. There may be some folks still in circulation who will be unearthed by lawsuits who haven't already been unearthed by the criminal prosecutions and all the other things that have gone on. But you're not talking about substantial numbers of people, I don't believe. But at any rate, that's not a subject we dealt with, and we felt for good reason. Other questions? Yes, sir.